evidence and as well as the two different issues regarding the jury instruction, and then if we have time I may get into the other issues. Regarding the insufficiency of the evidence, the question for this court is the evidence sufficient to convict someone of attempted murder if the allegation by the accuser is simply that someone drew a gun and pointed it at the accuser? And I've cited a couple of different...
That's not exactly all that happened in this case, right? I mean, we just don't have pulling a gun on a police officer. We have a little bit more than that. We have a struggle. We have an instruction from a police officer to a suspect to spit out something in his mouth, correct? So there's a little bit more that I'd like for you to, when you say what your facts are, be honest about what the full record supports in terms of what the facts are.
Right, and I'll get to that in just a second. But to answer that first question, is pointing a gun at someone sufficient? I've cited a couple of different cases from other jurisdictions involving similar facts, People versus Chandler from New York and State versus Klein from Ohio. And they both held that these types of incidents where you point a gun at someone and then there's a struggle, that's not sufficient for this type of crime.
But New York has a unique they have like a trigger test. That's something unique to New York, not other states. They require proof that your finger is on that trigger before the offense can be elevated to something more than assault.
My understanding, and I was going to say next, my understanding is that if that's all we got is pointing a gun at someone, that the law should be clear, even in Tennessee, not just New York and Ohio, the law should be clear that it's not sufficient for attempted murder. And we do have a couple of cases talking specifically about a trigger. Like we've got a case, I think it's Daniels, where it specifically says pulling a trigger, even if the gun doesn't fire, then that's sufficient for attempted murder. If you point the gun at someone and pull the trigger and your gun jams, obviously you could be attempting to murder. Or if there was one case where someone wrestled a bailiff in the courtroom and he didn't pull any trigger, but he said, "I'm going to shoot you," that was sufficient.
I guess my question goes back to Judge McMullen's first. That's not what we have here. We have more than someone just pointing. So why take your time here to argue these cases that are just a gun being pointed at someone?
My contention is that, all right, so then the next question that Your Honor's alluding to is there, if we do have more, if more is required, which I think everyone pretty much agrees on, then is there sufficient evidence that Mr. Moon pointed a gun at someone and pulled the trigger in this case? And what we have, the testimony from the officer on page 109 of the transcript is, "Thank God I prevented him from pulling it," referring to the trigger. And specifically the allegation here was that, and the allegations here, this whole issue was developed a good bit more here because I changed my strategy after the first trial. It was developed a good bit more here than it was in the first trial. It really wasn't developed at all in the first trial. But in this trial, the officer added this new allegation where he said that he froze once he saw a gun pointed at him. And so under Tennessee law, for an act to constitute a substantial step, all the facts and circumstances have to fully corroborate the intent to commit the crime. Here the officer said, "I looked back and there was a gun pointed at my lower ribs in this general area. So I freeze for a second, expecting the shots to hit my vest initially, but nothing happened."
Isn't there testimony that during the course of the struggle here, at least looked at under the Jackson standard, that there's an attempt to turn the gun towards the officer, that there's an attempt to pull the trigger on the officer? I mean, it's under the Jackson standard. Why isn't that enough?
Well, because under the Jackson standard, we have to accredit what this officer says, and he doesn't say that there were attempts to pull the trigger. What he says is, "Thank God I prevented him from pulling it," meaning it wasn't pulled, and he.
But that, I'm trying to really understand your argument. What I'm hearing from you is that in order for there to be sufficient evidence to support an attempted murder, there has to be, the trigger has to be pulled.
There has to be a substantial step, and in this context, when you don't have anyone saying, I'm gonna shoot your ass, as in one of the prior cases, I contend you basically do have to have a trigger pull. The statute doesn't require, I mean, it doesn't say there must be a trigger pull, but I'm not sure what else we could point to other than the gun being pointed at someone and the trigger being pulled.
The surrounding circumstances.
Right. And so what we had is, the allegation is that after the officer froze and wasn't shot, even though he thought he was going to be, that he supposedly grabbed the gun and pointed it away from him. And then that's the part where he said, thank God I prevented him from being able to pull the trigger. He admits he didn't see the trigger ever pulled. There was testimony and a courtroom demonstration that this gun, whether the gun's in or out of battery, makes a sound when the trigger was pulled.
Let me stop you just for a second, because again, I really want to understand your argument. This is not a situation similar to some of the cases involving this issue, where an individual points the gun up in the air for purposes of, trying to scare someone like that. And it's not a situation where an individual brandishes a gun. This situation involves a struggle in close proximity to another individual. So I'm really trying to see how you are so isolating the trigger pull from the circumstances of the offense in this case.
I mean, respectfully, Your Honor, I'm not trying to isolate it. I'm trying to look at every point of this struggle, this supposed struggle, and trying to figure out where the attempted murder could possibly come in. And what we've got is undisputed facts that the officer grabs the guy by the neck, and then the allegation that the man then pulls a gun in response and points it at the officer and doesn't fire. The gun's then supposedly wrestled away, and then the officer saying, I prevented him, thank God I prevented him from being able to pull the trigger. I didn't see the trigger pulled. It's undisputed from the proof that the trigger makes a sound when it's pulled, and there was no sound, the accuser says. There was only silence. And then, ultimately, if the officer's saying, I don't know if the trigger, basically, he came close to just admitting outright it wasn't pulled. That's what the whole thank God it wasn't pulled was about. But ultimately, his position was just, I don't know for sure. And I don't know for sure is not, I do know beyond any reasonable doubt that it was pulled. And frankly, even if it had been pulled, if we're going to just speculate and guess that it had been pulled, the proof is clear that at the point when it theoretically might have been pulled, the gun was pointed away from the officer. So it could not have, if Moon for some reason just wanted to pull the trigger and not shoot anyone while they're wrestling over the gun, it would not have killed the officer. He specifically, it's on page 64 and 65 of the transcript, he's talking about, so you feel this squeezing sensation on the gun going on while you're still fighting with the gun, is that right? Answer, yes. Question, and the gun is coming closer back towards you, answer, yes. And so and then he elsewhere, he says it's coming closer toward him, and then when he's asked about that, on page 114 of the transcript, he again clarifies that the gun never made it back to be pointed at him. So the only time when it was pointed at him is the initial time when he supposedly froze and he wasn't murdered. And then it's pointed away from him. It's pretty clear the trigger wasn't ever pulled, but even if we're going to guess that maybe it was pulled, it wasn't pointed at him, and so it couldn't have killed him. And so that's really what my argument is all about. And then I've cited a federal case, Nash versus Eberlin, and that's the 2007 one, because there's a 2006 one as well. And in that case, someone brought a gun to an argument, and then it went off during a wrestling match, similar to here. And there the court found that there was insufficient evidence for, it was basically assault with intent to injure, something along those lines. So analogous to what we have here. And not only was the evidence insufficient, but it was so insufficient that even under the Anti-Terrorism and Effective Death Penalty Act, where they have to give they have to defer to the state, they still found it violated the 14th Amendment. And so basically they were finding that no reasonable state court could have found the evidence sufficient to convict. And the exact same thing should apply here, and therefore the case should be reversed and dismissed. But if that doesn't ultimately win the day, we have raised a very strong issue with regard to the jury instructions. And ultimately, the jury instructions have to be.
Counsel, can you raise the ineffective assistance of counsel argument against yourself for your practice at trial? And what are the consequences for your client of raising an ineffective assistance of counsel claim on direct appeal with regard to their post-conviction proceedings?
The consequence is that basically he gets only one bite at the apple, and so if he loses there, he would most likely try next in federal habeas corpus court instead of post-conviction.
Okay, let's talk about that. How do we know that your client has entered a knowing and voluntary waiver of the conflict?
Well, we filed a motion for a motion by Mr. Moon to waive the conflict where we included an affidavit.
But is that sufficient? Is an affidavit sufficient? Because everyone on this panel has read your materials. But generally, when a waiver of a right takes place, a valid waiver, it is in court, under oath, and subject to the scrutiny of the trial judge in terms of, the understanding of the individual of the right that's being waived. None of that has happened here. So why should we allow the waiver at this point in the process?
It is under oath because it was done before a notary and it was done under oath, but I agree it's not done in front of the trial judge. I would just contend that's not dispositive and it's not absolutely.
Why? When the defendant can very well come back on post-conviction and say, that never happened. That never happened. And because it wasn't done in court, it's invalid.
I don't realistically see how he could come back and say it never happened if it got a notary verifying his affidavit where it did happen.
You don't realistically see his ability to say, because I was never brought in court and questioned about potentially another ineffective assistance of counsel claim, because we know how wieldy ineffective assistance of counsel claims can be. It's a large umbrella that individual claims can be made under. You can't anticipate all of them at once, or maybe you can, but in advising the defendant in open court, do you not agree that there is a difference?
I mean, I really don't agree that there's a difference, other than as you're suggesting, if he were to just say, I didn't sign that, that's someone forged my name.
No, I didn't sign it. Making the specific argument, what our rules require, what our case law requires, is an in-court waiver as opposed to an affidavit. But
well, I mean, you talk about what our case law requires, and I think you're citing the Frazier case, which is what the state brought up. And procedurally, this case is a little bit different from that. I agree it's not a lot different, but it is a little bit different because that involved an actual post-conviction appeal, whereas this is a direct appeal.
You wouldn't disagree, counsel. There's serious consequences of raising a ineffective assistance of counsel argument on direct appeal, in terms of having another attorney have an opportunity to look at your work and determine whether they see a basis for ineffective counsel that you may not have seen or observed. And they're essentially, the claim becomes limited to you were ineffective in raising the ineffective assistance of counsel claim.
Well, regardless of whether there may be serious consequences, the Frazier case does allow the defendant to waive the risk of those consequences, and
under certain circumstances.
I mean, the only difference between the circumstances here is that it's not done in court, as Your Honor is saying. And so if Your Honor ultimately finds that the motion to consider the post-judgment facts is not adequate, I guess the remedy would then be, and it would waste a bunch more of Mr. Moon's time about getting out of jail, but I mean, the remedy would then be to send this back to Judge Lockhart and then have us come back here in 4 to 6 months or however long it takes to deal with the issue a second time. But
well, I wanted to ask you this before your time runs out. The conflict notwithstanding, let's just assume there is no conflict. What evidence is there in the record that that you were ineffective?
The evidence in the record, even without my affidavit, which is allowed to be considered under Rule 33 as testimony in a motion for new trial, even without that, you can already tell just from the trial transcript that I wanted this instruction. I argued for this instruction. I asked for this instruction, and when it was denied, I then filed an arguably late piece of paper again requesting the instruction. So clearly I wanted it, and if it was late, then I was negligent in filing it late. So you really don't even need my testimony, but to sort of have some icing on the cake, I filed a declaration or an affidavit with my motion for new trial where I just came right out and said I had no strategic reason for this. I was negligent. I was not familiar enough with the statute. And under Moore versus State, as well as Strickland versus Washington, a defense counsel is required to pursue every defense available unless there's a strategic reason for not pursuing it or for foregoing that avenue of.
Sure, but that only speaks to the deficiency prong. It doesn't speak to the prejudice prong.
Right, but Judge Easter, I think, was asking me about
Okay.
prejudice or the deficiency prong. And so I'm saying the record is clear that I was deficient, and that would answer Judge Easter's question.
Okay.
Thank you all.
Thank you, Mr. Justice. All right. You're not Ms. Huppenthal. You filed the notice of appearance. I think I saw that.
Wednesday
a
or
while
Thursday
ago.
of last week, yes, Your Honor. Good morning, Your Honors. May it please the Court. Garrett Ward on behalf of the State of Tennessee. Your Honors, this Court must affirm Mr. Moon's conviction for attempted second-degree murder and the related firearms charge because the evidence is sufficient to support these convictions and because his jury instruction claim, the standalone claim has been waived, and he can't bring the sort of attendant ineffectiveness claim that he's seeking to bring. I'll start with sufficiency, and I'll briefly run through the facts for the Court because at various points in opposing counsel's argument, and understandably so, he was really trying to present this Court with sort of the idea that there was this sterile, very slow-developing situation, when in fact what happened here was anything but slow developing. What happened here was utter chaos. So what the proof shows is that Mr. Moon encounters Officer Wilder of Coffee County Law Enforcement. When Officer Wilder, he sees Mr. Moon duck into this sort of furtively duck into a trailer at a trailer park he's observing. Officer Wilder gets confirmation from dispatch that Mr. Moon has a warrant out for his arrest. So he goes and knocks on the door of the trailer, confronts Mr. Moon. There's a brief interaction that's fairly as friendly as these interactions can get, at least what we can see from the record.
Did they actually have a drink together?
I don't know that they had a drink together, Your Honor. There was
I wondered
there was unexpectedly a 40-ounce of beer introduced into the situation. I believe a passerby handed one to Mr. Moon when he asked for something to drink. If the record bears out that Officer Wilder took a drink with him, I'll certainly see to the record. That's not
I just thought that was.
That's not my
One
recollection.
of the briefs indicated that the officer allowed him,
He certainly didn't intervene and stop him from taking a sip of beer.
and I wondered what Judge McMullen thought. I wondered if he had one too. Yeah.
The thought crossed my mind, Your Honor, but I can't specifically
not in the
speak
record,
to
okay.
Officer Wilder consuming any alcohol. The record, from my recollection, doesn't bear it out, but it certainly bears out that he saw Mr. Moon get this 40 and begin to drink it. Ultimately, though, the other thing he sees is Mr. Moon try to swallow a baggie of what Officer Wilder visually believes to be methamphetamine. At that point, there's a struggle. Officer Wilder's trying to fish this bag of methamphetamine out of Mr. Moon's mouth before he swallows it. He ultimately gets the baggie out of his mouth. They separate briefly, and then the officer goes to arrest Mr. Moon, and this is really where the most operative facts for this crime occur, but I think the background's important. When the officer goes to arrest Mr. Moon says, "This is not effing going to happen." Mr. Moon pulls out a loaded 9mm handgun that he had acquired at some point inside the trailer and points it directly at the officer. The officer understandably then sort of grabs at this gun that Mr. Moon is pointing at him.
So in the facts, I just want to make clear that the defendant was made aware that he was under arrest prior to the introduction of the gun.
Your Honor, I won't stand before this court and say that the officer said, I'm placing you under arrest. What the facts most clearly show is that the officer sort of making to sort of pull his arms behind him as to handcuff him. So it's clear that at the very least he's trying to sort of physically restrain him with handcuffs or detain him. So that much is clear, if that answers Your Honor's question. Okay. So that's when the gun is introduced to the situation. The officer very clearly testifies that as he's grappling with this gun that Mr. Moon is trying to point it at his head, and that he testifies that on multiple occasions he can feel the gun. I believe the word the officer uses is torquing or spasming. And then he directly says numerous times throughout this record, he directly says, Mr. Moon was trying to pull the trigger. I could tell that because I'm holding onto the gun. No, I'm not staring at the trigger. It's this chaotic situation. I can tell he's trying to pull the trigger because I can feel the gun sort of jerking. I can feel it torquing. And under the standard for sufficiency of the evidence, that's plainly enough to get us to attempted second-degree murder. My friend on the other side has sort of posed the question to this court of suggested that the question in this case is pointing a gun sufficient? Your Honors, that's not the relevant question. The relevant question is pointing a gun at somebody and trying to pull the trigger sufficient, and the answer to that is plainly yes. If the gun had misfired, if the gun had jammed, or if, as in the case here, the gun doesn't fire not because of any action of the defendant, of any showing by him that he doesn't intend to pull the trigger, if the reason the gun doesn't fire is he is physically stopped by another human being, if that's all that prevents it from firing, that is easily sufficient for attempted second-degree murder. The defendant is acting with the intent to fire this gun at Officer Wilder. He takes a substantial step towards doing that by attempting to pull the trigger or deactivate the safety. I'll note that the gun is ultimately found at the scene with the safety deactivated. So he does take these substantial steps while he's acting with the intent to cause this offense. This evidence is sufficient.
General, we haven't touched on the Miranda question.
Certainly
I've got
not.
a couple questions in that vein. One,
Absolutely.
I'm struggling a little bit with how you're not in custody if you've been shot 5 times. In terms of, and custody it's an arrest, or it's essentially the equivalent of an arrest in terms of limitation of your movement. If an officer, and this isn't, we're not talking here about a third party having shot, this is a law
Certainly.
enforcement officer that engaged in the shooting here. How is that not the equivalent of depriving somebody of their freedom of movement on a level of an arrest? I mean, you put handcuffs on somebody, and shooting them 5 times isn't the same thing in terms of, or at least an equivalent thereof?
I think our argument here, Your Honor, is less that about technical discussions of custody. It's more of even if he is in custody, is he being interrogated? I think is where our argument more lies.
Okay, so in terms of interrogation, right? So interrogation, not just questioning, but any words or actions, and correct me if I'm getting the standard wrong, if I'm misstating, any words or actions on the part of police that should reasonably likely to elicit an incriminating response from the suspect. Now, if we've got the officer standing next to somebody or near somebody and saying, he pulled a gun on me, he had warrants, I shot him, he pulled the damn gun on me. Really? He pulled the damn gun on me. And there are multiple other statements to that effect. How is that not something that is reasonably likely to elicit a response from the person who's being accused of having shot or tried to shoot the officer? And I'm not saying he directly asked him a question, but
Certainly.
That's not the standard for interrogation, is it?
Your Honor, it is certainly possible that there can be almost these sort of interrogation by byproduct is almost what the cases seem to suggest. That I forget the case that my friend on the other side cited, but
I think it's Northern.
No, that's the case.
Sure.
Yes,
and
Northern, and there's
numerous examples, and Christian burial speech case.
Certainly.
And so, how if an officer's saying he shot me, how's that not reasonably likely to elicit a response?
So I think what this court should focus its inquiry on, because I think that's what Northern and sort of the related cases bear out, is the officer, is he sort of making these statements with the intent to draw forth this?
Is that the test with regard to an interrogation? And I thought Miranda's test, and Miranda by definition is designed to remove
Certainly.
subjectivity. It is supposed to be an objective, reasonable observer analysis. So why in the world do I care what the officer's intent was if I'm engaging in a Miranda analysis?
So,
That's
yeah,
not the way we look at Miranda, right?
I do absolutely judge Usman sort of in the classical, sort of normal Miranda field, absolutely. We get into this odd area of Miranda when we're specifically talking about these byproduct interrogations, where we all agree that there's some period of time where the officer is talking to Mr. Moon. I don't believe that's where his argument really lies. I think his argument, as I understand it, is that when the officer is talking to these other people, and I take your Honor's question to be going to the same thing, when he's talking to these other people, is that something that's going to reasonably cause Mr. Moon to respond? I do think an objective observer and watching that interaction, I think they would rightly consider sort of who is the extent of the officer's communication with these other people, the length of it, and is the officer, sort of slyly talking in a way where he's expecting Mr. Moon to respond. That was sort of my point earlier, that while agreedly Miranda rightfully attempts to remove subjectivity, that when we're in these odd liminal zone cases where the officer we know is not directly talking to Mr. Moon, is talking to others.
The response is the key, though, right? Triggering the response. So why, walk me through again, though, why isn't it somebody saying this about me? This comment's being made. He tried to shoot me, multiple times over the course of about 7 minutes. Those statements are being made. How is it not reasonably likely that I'm going to say something in response to that? It would seem odd to me that somebody would not respond to that.
Your Honor, I think in this situation, we have Mr. Moon. He's laying on the ground. He's receiving life-saving care. There are at the time we're discussing, Officer Wilder sort of left aside. Other people are there. Officer Wilder is dealing with other people. I think an objective observer wouldn't necessarily think that Mr. Moon would feel compelled to respond when the officer is not talking to Mr. Moon, is not speaking in this elevated voice to sort of specifically draw Mr. Moon out to get him to talk.
Is the test, though, from Miranda? I mean,
Which,
it's reasonably likely to elicit.
Pardon me, Your Honor. I don't think that it is reasonably likely to elicit it. Officer Wilder is not speaking to Mr. Moon. He's talking to other people about what happened. And I want to sort of draw the court back to how chaotic this situation was. What the officer is doing here.
I'm not trying to fault
Certainly.
the officer at all.
Certainly.
In terms of intent, not at all. But it's one where I am still struggling to see how it's not likely that you're going to say something in response to an officer saying he tried to shoot me.
And I understand the court's concern. I would certainly, as is often the case with cases that come across my desk, I would prefer if the facts bore out slightly differently. But what we really have here is a fairly brief encounter between this officer and other people. Yes, Mr. Moon is discussed. Yes, Mr. Moon's actions are discussed. Mr. Moon isn't addressed in any of these. This sort of discussion with other people is not prolonged. I believe in Northern we're running at 15. The sort of discussion with this, I think in Northern it's a detective to detective discussion. It goes on for 15 or 20 minutes. And really that's one of the things that I think Northern really looks at is the longer you as the defendant are sitting there listening to other people talking about you, the longer that goes, the more likely you are to respond, the more reasonably likely it is that you're going to respond. I think that's a pretty key difference in this case, that we have a fairly short period of discussion between Officer Wilder and these third parties. The other thing I would point Your Honor to is we have a difference in setting here. To me, it's a pretty critical fact in Northern that we're in a sort of a sterile, non-chaotic environment where, and I think it's either in an interview room or the back of a police car. Here we're out in the middle of a trailer park. There's just been a shooting. There's going to be countless conversations going on between bystanders and law enforcement as everybody is trying to figure out what happened. Officer Wilder is certainly part of these, but I think the difference in setting between Northern in this case is a critical distinction. So I think the combination of difference in setting and shorter length of these conversations makes this qualitatively different than Northern in similar cases, such that I don't believe that Mr. Moon would be, that a reasonable observer would find him sort of reasonably likely to respond. I would like to address the jury instruction issue. First is a
But
standalone.
did the state file a response? Did we see that?
I don't think you filed a response to the late filed
To the-
motion to consider post-judgment facts.
Did you-
I did not, Your Honor.
Did you feel the need to respond to that?
Insofar as the affidavit sort of being a post-judgment fact to consider, the state will leave
What's
it
your
to this
position?
court's discretion.
You're not gonna take a position?
On this court considering it, if this court wants to consider the affidavit, the state takes no position on
Okay.
that. But as for what the affidavit says, the state does have feelings about whether or not that affidavit leads to a valid conflict waiver. But as for consideration, I'll leave it to the discretion of the court.
Okay, so you think that the affidavit is not a valid waiver?
It's not enough, Your Honor, to be
Okay.
a valid waiver
Okay.
in this case. I'll briefly address the standalone claim, and then
Sure.
I'll discuss ineffective assistance. The standalone claim is waived. The language of 4018-110 is crystal clear that for an issue like this to be preserved for plenary review, the written request must be made prior to the jury being charged. I don't think there's any dispute that did not happen in this case. So this issue is a standalone issue, is reviewable solely for plain error. The defendant hasn't, and it seems rather specifically, has not requested plain error. So this court should decline to subject this issue to plain error review because it's waived, and the defendant hasn't requested plain error review. Instead of plain error review, the defendant has the defendant's trial counsel, who now represents him on appeal, has asserted a claim of ineffective assistance against himself for not filing this written waiver. Your Honors, this is a claim that opposing counsel simply cannot make, that he's conflicted from making. There is a cornucopia of case law on this topic, and the holding is rigidly consistent, that there is an inherent conflict in an attorney raising an ineffectiveness claim against themselves. Perhaps the leading cases in Tennessee are Frazier and McCullough, both of which are cited in the state's brief. Yes, there are going to be some procedural differences between all of these cases. Perhaps the number one of which here is that this is an ineffectiveness claim arising on direct appeal rather than post-conviction, which is a little odd in and of itself. But these procedural differences are not distinctions that make a difference as far as the nature of the conflict. This is a claim that opposing counsel is conflicted from making. And it was incumbent on the trial court, when this claim was presented to it, for the trial court to recognize that conflict. Frazier places an immense amount of responsibility on trial courts when it comes to allowing claims that present a clear conflict, which this one just flatly does.
Well, no one contests it's a conflict. The question is whether there's a valid waiver.
At times, Your Honor, I did take my friend on the other side to be contesting that there was a conflict. Perhaps I misread perhaps I misread or misinterpreted his brief and reply brief. I interpreted his materials as several times saying there was no conflict here because he was admitting fault. The state outrightly rejects that notion. As for waiver, there's not a valid waiver here. I think perhaps the best piece of language I can point this court to is from Frazier. And Frazier quotes a U.S. Supreme Court case, Wheat, that says, for these waivers to happen, the trial court the trial court, who has not been presented with this affidavit, that the trial court must satisfy itself that there has been a valid waiver. And what Frazier says is the reason for that is that there's a great deal of unpredictability as far as the dimensions of the conflict go, specifically with ineffective assistance of counsel. It is certainly admirable to some extent that my friend on the other side is willing to admit that he may have made a mistake on this one issue. But the unpredictability of the dimensions of the conflict, what the court is clearly alluding to there is the entire galaxy of decisions that went into Mr. Moon's trial. As this court is well aware, the criminal proceedings with Mr. Moon have been going on for some time. There were a lot of decisions that went into this case, and none of them are being examined
General,
here.
if there's not a valid waiver here, that means that the issue not appropriately before the court, and there's no prejudice to the defendant in this case to being able to raise this on post-conviction. Is that correct?
I believe the court could fashion such a remedy, Your Honor. I think the appropriate remedy in this context would be to say this claim was conflicted from the beginning, from the time it was presented. I believe that's sort of what the Tennessee Supreme Court hints at doing in Frazier. I believe that's exactly what they do with the conflicted claim in Frazier, is they sort of sponge away, and it's as if it never were, because the trial court had a duty to prevent the conflicted claim from being presented, and that didn't happen here. So I do believe what this court could do in its opinion is say that there was a conflict from the beginning, because there was no waiver, so the claim never should have arisen.
So assume that there is a valid waiver. Is there prejudice here?
I don't believe so, Your Honor.
Can you speak to that? Why?
Because nothing in this record speaks to adequate provocation. The sort of underlying this ineffectiveness claim is the lack of written request for a voluntary manslaughter instruction, so we could have attempted voluntary manslaughter as a charge. What that charge rests on is adequate provocation. Here, what the proof very clearly bears out is that the discrete action that causes Mr. Moon to draw his gun and attempt to fire on this officer is being arrested. Yes, there is a struggle. There's sort of varying depictions, but from the officer to Mr. Moon to even various bystanders about how, pardon me, about how sort of intense that struggle was. But what is crystal clear from this record, what all of the proof shows, is that what prompts Mr. Moon to fire is being arrested.
So in order for there to be a valid voluntary manslaughter,
There has to be adequate provocation.
Sure, but there was no proof in this record of that?
No,
To
Your
support
Honor.
such an instruction? Okay.
I believe there was no proof in the record because if I may respond.
Sure.
There was no proof in the record because what the record shows is that the discrete action that causes him to pull his gun and attempt to fire isn't this struggle, it's the attempted arrest.
Okay.
And that's not adequate provocation. Unless this court has further questions, I would ask that you affirm.
All right, thank you, Mr.
Thank you, Your
Boyd.
Honors.
Mr. Justice, I think you have, did you say 5 minutes?
Yes, Your Honor.
Okay.
I'm going to try to fly through several different points real quick here, but just to clarify my argument about what the question ultimately is for, well, on insufficient evidence, the officer, the opposing side testified, the opposing side said that Mr. Moon was being arrested and that his hands were being put behind his back or whatever. That is simply not the case. If Your Honors look at page 115 of the trial transcript, he was specifically asked, and you would agree, you didn't ever specifically tell Mr. Moon he was under arrest. Answer, he didn't give me the chance. And you would agree, you didn't ever ask him to put his hands behind his back so as to be handcuffed, right? Answer, he didn't give me the chance. And so there really was no arrest here. There was no hands behind his back. There was no telling him he was under arrest. And I think it was also even undisputed that he never even heard any mention of him having a warrant out for him. So there really was no arrest here. What you had was a situation where a citizen was confronted by a police officer. The officer puts his hands around the man's neck, and then allegedly the citizen pulls a weapon. So ultimately the question for insufficient evidence is, if an officer comes up to you and chokes you, and you have a gun and you draw it and point it at the officer, but don't fire, even after the officer freezes and gives you a chance to fire, and then the officer then comes to his senses and grabs it and pushes it away from you, and then testifies in court, thank God he didn't pull the trigger, says he didn't hear any trigger sound when there would have been a trigger sound, didn't see a trigger sound, or didn't see a trigger pull because he wasn't looking.
Counsel,
Is there evidence?
Do you dispute that the officer testified, or the officer's testimony is consistent with attempts to try to pull the trigger?
I do.
Angle it towards his head?
I think I do dispute that, but ultimately the officer was kind of flipping back and forth between, he was trying to, basically testify about what Mr. Moon was thinking, and I was objecting to that, and then ultimately, as I said, I confronted him with his prior statement that the trigger wasn't pulled, And then he said, thank God it wasn't pulled, and ultimately, can't really say whether it was pulled. So I mean, this is the first I'm even hearing today about the issue being whether he was trying to pull the trigger. Either he did
Wasn't
pull the
briefing
trigger or he
getting into
didn't.
the torquing issue in terms of, I read the state's brief as addressing the torquing aspect, the attempt to turn the gun towards his head, and isn't that in the state's brief?
I
in
mean,
this case?
there's no dispute there's no dispute that in the light most favorable to the state, the gun was pointed, it was pushed away, and then Mr. Moon was trying to point it back. But then the question is that an attempted murder, or is that an aggravated assault, a self-defense, somewhere along those lines? And if no trigger was pulled, then it can't be attempted murder, I would submit, because you don't have any other.
Even if he's trying to pull the trigger, even if he's trying to get the gun angled so they're struggling, and if the officer's testimony is consistent with he's trying to turn the gun to my head and I'm fighting with him over the gun and I can feel him trying to pull the trigger, that's still not enough?
He says, I can feel a movement while they're fighting over a gun, so I dispute that that's enough. And ultimately, when he basically admits, I don't know it was pulled, thank God it wasn't pulled, I would submit, Your Honor can't say beyond a reasonable doubt that it was pulled if the officer's basically admitting that it wasn't. In any event, the question is there sufficient evidence in light of all those facts of whether the trigger was even pulled, and if so, we take into account the fact that, it's while the gun's pointed away from everyone, is that sufficient evidence for attempted murder? I just submit not. I don't see how it could be.
I know you're running down on your time, and I'm going to give you your time, but the sufficiency, the same facts it was already affirmed by the Supreme Court when it went up the first time, correct?
No, Your Honor, that issue didn't go before the Supreme
It was
Court.
just
And the facts, as I've said, were developed a lot differently
They were
here.
different. Okay, so there were different facts from what went up?
I basically didn't even argue this point about the trigger being pulled to the jury in the first trial. I didn't ask any real questions about it. The only thing that did come up was the officer, I think, admitted that he didn't hear a sound.
Okay.
So it was a good bit different. That's why I'm arguing it again. I don't see how could be any sufficient evidence. On the jury instruction, state said there was we have to look at the jury instruction in the light most favorable to granting the jury instruction. Donald Woods testified that the officer engaged in aggression. He said he grabbed Bill by the throat, threatened to tase him. William Moon testified that he was choked, that he could not breathe, that it seemed to go on for a long time. J.J. Smith testified that the officer's hands were still on Moon's face up until immediately before the shots rang out. And so if that's not enough to provoke, we're not even really talking about self-defense here. We're talking about was the aggression sufficient to provoke a reasonable person to act irrationally? In the light most favorable to the defense, the answer is clearly yes.
Was there a self-defense charge given here?
No, Your Honor, we didn't. I felt like that was sort of
Okay, you
going a
kept
little bit
mentioning
too
that,
far.
I just didn't know if that was.
I think
what
I
was-
considered that, but it just seemed kind of
All right.
pointless. Anyway, ultimately, I would just suggest, in answer to Judge Usman's question a minute ago, we cannot raise this on PCR if it's already been decided by the trial court and decided against Mr. Moon. And so the only options here basically are to either accept our waiver of any alleged conflict. I do dispute that there's a conflict, but to accept that, or to remand it to Judge Lockhart and have him figure out whether you all can even address that issue and then bring it back and possibly allow for supplemental briefing or whatever. But I would submit those are the two options and not PCR. Ultimately, I do ask that the judgment be reversed and the indictment dismissed.
Thank you, counsel. Thank you both for your arguments and your briefs. We appreciate it, and the matter will be taken under advisement. I think that concludes our docket for this morning. All right, so we will stand adjourned until the April session of the Court of Criminal Appeals.